My Lords, good evening. I rise in support of amendments 141BA, 141C and 142B, and it's a pleasure to support the noble Lord Hunt on these amendments. And I declare an interest as a businessman and as one who wishes to see the wheels of commerce and thus the economy moving smoothly and not unnecessarily clogged up. My Lords, as far as insolvency goes, this bill presented an opportunity, one that I urge the government it can still grasp, to make insolvencies more efficient and less destructive of the economy. The law currently says that in most cases where workers are to be made redundant, as we have just heard, a 90-day consultation is required regardless of insolvency or not. But if a company is insolvent, consultation is necessarily spurious. The employees have lost their jobs, period. And the receivers have to move towards instantly, not waiting 90 days, realising the assets. So they don't wait 90 days. So because of this rule, they then break the law because they're required to give 90 days. Two laws are in conflict with each other, and one of them has to be broken. The swifter the assets of a failing organisation can be reorganised, the more likely it is that productive economic activity can be continued from these assets. In the US, where these things are done much better, a study some time ago found that only 4% of assets were lost in a bankruptcy. 96% went on to be productive assets under a new organisation. So anyway, now the law has been broken necessarily in these cases because the receivers are doing their duty to achieve a speedy liquidation. And so, because the law has been broken, the lawyers move in. Now, the noble Lord, Lord Pitt Keithley, who I'm delighted to see is in his place, referred just earlier to ambulance chasers. Now, there are many lawyers, my lords, in this House, and every single one of them is, of course, honourable and valuable. But we here are talking about no-win, no-fee lawyers which, who can be deeply pernicious, both in practice and effect. These lawyers advise all affected employees that they have a case that they can take to the employment tribunal because they haven't been consulted, and that they will certainly win that case. And these lawyers, these no-win, no-fee lawyers, refer to this case as free money. Dear employee, you've got free money because you haven't been consulted on a 90-day period. These employees already get their redundancy money, their statutory sick pay, their holiday money, and so forth. They get it all ahead of any other creditors. They are not disadvantaged. This 90-day money that they get by going to the employment tribunal is 3 months' bunts on top of everything else. I don't think that can have been intended, but it's certainly what the outcome was. And who pays for this? Because there's no such thing as a free lunch, as we know, my lords. If the company was truly insolvent, there won't be enough money for everybody. So there will be losers when this money is paid to the employees. Losers such as suppliers, HMRC, aka the taxpayer, of course. And they will lose more as those workers get their 90 days' pay. Now, I refer to one of many examples, GoCentric, a Glasgow-based call centre that suddenly went bankrupt on December 19, 2022, laying off around 600 employees just before Christmas. Now, there's a whole story behind that all of us can derogate, but now the receiver's faced with the fact you've got 600 employees who have to be laid off immediately. That's what receivers do. And these receivers are honourable people running a very important economic activity for this economy. Enter the lawyers into this go-centric situation, writing to redundant workers, advertising what they actually wrote in the letters to employees, free money, which the employees replied to. They went to the employment tribunal. The money was obtained for 200 workers who had already received all their statutorily due redundancy payments. I really don't think this can have been intended when the legislation was written, but so it was. But anyway, now, my lords, we have a wonderful opportunity in this bill to rectify this most likely unintended clash of legislation by removing the 90 days consultation requirement in an insolvency, since, as we know, consultation is irrelevant, indeed impossible, in a liquidation. So has the government wisely seized this opportunity, my lords? Has it rushed to validate its claims of fiscal prudence? It has not. Far from it. Indeed, it is bizarrely now proposed in this bill to increase the 90 days to 180 days. A full 6 months of free money on top of statutory redundancy money, taking precedence over HMRC, suppliers and others. This all makes it more likely that their claims cannot be met, potentially precipitating further bankruptcies among suppliers. You will have heard many pitiful stories of suppliers stiffed out of payments by a larger company going bankrupt and themselves having to go bankrupt. This provision, my lords, makes that more likely. There is no free 180-day lunch here, my lords. And we have a further problem here, which may not have been considered by the government in putting forward this bill, which is that if these payments fall short, which necessarily they will in many, many cases, the redundancy fund is called upon to pay monies to workers. Redundancy fund that reports to HMRC, that reports to the Treasury. Now, have the Secretary of State and the noble Minister inform the Chancellor that they are legislating to increase the Treasury's outgoings by a significant amount in future years, not to mention increasing the nation's welfare bill, which the government actually has a commitment to reduce. I wonder, I suggest that the government speak to itself and have a discussion about that. So, all of these concerns, my lord, and the same concerns apply to extension of the 20-employee person limit that the noble Lord Hunt referred to across an organisation, and to encompass distressed businesses, that is to say businesses that are in distress, that are calling in for financial advice but have not yet gone into immediate insolvency. An opportunity is being missed to sort all of that out. In short, my lords, I strongly urge the government to reconsider its wording in clause 27, recognise the impossibility of consultation in these circumstances, and recognise that the need to provide for statutory redundancy pay for employees is already fully taken care of in existing legislation. Awards from employment tribunals for failure to consult, whether requiring an extra 3 months' pay, 90 days, or 6 months extra pay, 180 days, will double up or more on these payments and will, in many circumstances, remove monies owed both to suppliers and indeed the taxpayer.